Hello, everyone. Welcome to today's webinar on Sports and Trademarks, a Canadian Perspective. My name is François Larose. I'm a principal at Smart & Biggar in the Montreal office. At Smart & Biggar, so we specialize in all areas of intellectual property law. We're an IP boutique law firm, although we're pretty big for a boutique law firm, over 180 IP professionals in 6 offices across Canada. We are thrilled to be sharing our insights with you today. But before introducing our speakers and diving into the content, I'd like to start with a few housekeeping details. So our formal presentation should last about 45 to 50 minutes and will be followed by a Q&A session. You are welcome to submit questions at any time during the presentation by clicking on the Q&A panel at the bottom of your screen. So we'll try to address as many questions as we can during the session. Also, this webinar is being recorded. So after the session, you will receive an email with a link to the recording with a PDF copy of the slides, either in English or French, according to your preference. And finally, at the end of the webinar, a survey link will pop up. So we would appreciate if you could take a few moments just to share your feedback on today's session and let us know what other topics are you are interested in learning in the future, as long as it's IP law, obviously. Now, for our speakers, I'm very happy to introduce our 2 presenters. In my view, 2 of the brightest minds at Smart & Biggar, Jamie Lynn Kraft and William Audet. Jamie Lynn is a principal in our Ottawa office, and William is an associate in the Montreal office. They both have significant experience in protecting and enforcing sports brand. The topic for today's presentation, it stemmed from the theme of the World IP Day, which was on April 26, which is IP and sports, ready, set, innovate. So Jamie Lynn, I'm passing the puck to you. Maybe start with one general question, if I may. So what are some of the unique challenges that sports leagues or franchises face when selecting new brands?
Thanks so much, Francois. I think that, and if we can go to the next slide, I think that any good trademark attorney is going to tell you that clearance is a foundational step in the brand selection process, regardless of the industry. Now, what do I mean when I say clearance? I mean conducting various levels of searching to determine whether a trademark is available to use without infringing the rights of others, and whether it's something able to be protected. That is, something which can function as a trademark and is not diluted or commonly used in the industry. But what makes clearance all the more important for sports brands is their popularity. People love sports, and they especially love their sports teams. So when we think about launching a brand for a new team, we're talking about something that's going to be core to the team identity and the fan experience. That popularity also means that if we don't do clearance, or if we don't do it right, and we find ourselves in a position where we need to rebrand, that is going to be a highly public and embarrassing mistake, and certainly a costly one when we consider the level of investment that typically goes into professional sports brands. But if we get our clearance right, then we have the potential to grow a very valuable asset through licensing and merchandising. Let's take a look at our next slide. So now that we've decided it's a good idea to search, how should sports franchises go about clearing a new brand? An important consideration is where to conduct our clearance, geographically speaking. Now, certainly, we're going to want to cover the team's home country as well as any other country in which the league plays. But the inquiry might not stop there. If this is a sport where the games are expected to be televised, and if the broadcast and streaming regions go beyond the league footprint, then we may want to search in the viewership markets as well. Consider also where we'll be selling our merch, our hats, our water bottles, our jerseys, our flags, our teddy bears, the list goes on. If our merchandise market extends to even more countries, we probably want to search there too. And finally, if the league is looking to expand in the not-so-distant future, that's an important question. There are many real-world examples of professional sports leagues playing a few games a season in new test markets. If expansion is on the horizon, those expansion markets should also be included in the search. Let's go to the next slide. The next question to ask is what goods and services our team should include in its search. Well, the obvious answer is to include entertainment-type services, such as organizing sporting events and competitions and selling tickets to those events. If the games will be broadcast, consider broadcast and streaming services as well. Now, where things get a little bit more complicated is the merchandise, which can theoretically cover all manner of goods. Now, many in our audience today will know that in the trademark world, goods and services are categorized according to class. So, as an example, shampoo is in a different class from car tires, which are in a different class from banking services. This means that most clearance searching is done, or at least charged, on a per class basis. And so while our team would ideally search in all classes, a clearance project of that magnitude would quickly get out of hand and out of budget. Instead, our team needs to be strategic and search in the merchandise classes which will be core for it, which would usually include, let's say, clothing in class 25 and sporting equipment and toys in class 28. But, there could be others depending on the particular team. Let's go to the next slide. In clearing brands, sports franchisers are going to face another challenge that is unique to their industry, and that is that there are familiar themes which appear almost universally across sports brands. These are animals, strength, and nature. The wide adoption of these common themes results in a crowded trademark landscape, which is to say, there's a lot of the same names out there. So our fictional team, in this case, the Smart and Biggar Badgers, might run its clearance search and find out that there are already a lot of Badger sports brands out there. Now, coexistence may be possible in certain cases, such as if the brands are for different sports or different levels of play, or if the trademarks feature different distinctive modifiers. In our fictional example here on this screen, I would say that our Smart and Biggar Badgers semi-pro hockey team probably has a good chance of coexisting with the Little League Baseball batter-up Badgers, given the coexistence of other Badger marks for sports-related goods and services, as well as the overall differences in the team branding and customer base, or fan base as it were. Next slide. Before completing our clearance project, our sports team should make sure that we've covered all the bases. A trademark might be clear from a legal perspective, but are there any practical hurdles? Can we get the domain name and the social media handles we want, or are they already taken? Also, when developing our new sports brand, we should think beyond the team's name. We should consider the mascot's name and the team nickname, if any. Finally, if our sports team is going to be entering a new market where the language or social norms are different from its home country, we should consider hiring local counsel to guide us on the appropriateness of name selection to be sure we are not inadvertently about to launch a brand that could be culturally insensitive, as that could have significant negative reputational impact. Next slide. So here are our team's key clearance takeaways. Clearance is critical for sports brands. We should consider the relevant regions beyond the home market and relevant goods and services. We cannot forget merchandising. We should expect a crowded naming landscape and develop backup names early in case we need to pivot in the face of a potential obstacle. And we should think beyond the team's name to include other brand assets in our clearance project. So, Francois, I hope that answers your question about the challenges in selecting new sports brands.
Yep, thank you. It does. But I have a new question now. So we've done the clearance. What do sports brands need to think about when seeking to protect or to register their trademarks?
Great question. So if we go to the next slide, I would say that the number one consideration when seeking registered trademark protection for a new sports brand is timing. If we get this one wrong, it can mean the difference between owning a brand and being in a dispute about it. Ideally, we would file before making our public announcement about our new team's name in order to secure priority rights over anyone else who might try to file after the announcement. The risk with filing early, of course, is that the name usually needs to be kept a secret until the official announcement. But most trademarks office databases are publicly searchable and accessible shortly after filing. And so the secret's effectively out once you file. Well, one way to balance those two risks is to file multiple candidate names during the selection process so that anyone searching the public trademark office database would not be able to say with certainty what the new name is going to be, but you still secured the priority date for the eventual name. Next slide. The next question is where to file. And the answer is anywhere the brand will be visible, valuable, or vulnerable. The considerations for deciding the relevant jurisdictions will essentially be the same as for clearance. Where is the home team located? Where is the league located? Where are the broadcast markets? And where are the merchandise markets? Finally, if our team is planning to file in more than 2 or 3 jurisdictions, then we should probably give serious thought to whether we want to secure an international registration, which can provide a more streamlined entry of our applications into a large number of jurisdictions. Next slide. Of course, no application is complete without our statement of goods and services. Now, we're certainly going to want to include our core goods and services in classes 25, that's the apparel, 28, that's the equipment and toys, 38, broadcast and telecommunications, and 41, entertainment. But sports brands are often leveraged through licensing programs, sponsorships, and brand collaborations. These partnerships extend the use of the brand into a wide range of goods and services. We're talking not only about the typical merchandise found in the fan shop, but anything from food and beverages to financial services. And we want to have our registration cover that wide range of anticipated licensed use because our registration, which represents an exclusive right, underwrites the value of the license. The broader the scope of the registration, the broader the scope of the exclusivity, and the more attractive and valuable the license is to our potential licensees. Next slide, please.
So, Jamie, can I just interrupt 1 second? I have a question in the chat.
Sure.
Someone's asking, how can one file several different marks if there's no actual or intent to use?
That's an excellent question because, of course, in order to file an application, you should have an current use or an intention to use, even though you do not need to claim that in a Canadian application. The intention must still be there. I would say that if you're early in the clearance project, which is when I'm proposing to file these candidate marks, you don't know yet which one you're going to be using. So I would say that you do have a legitimate intention to use that. You just don't know yet. Maybe I'm going to use this. I'm not sure. If this is the right one, I will be using it. So I think that is a genuine intention, but it certainly is a good point and possibly open to argument that it's not genuine intention to use. But my position is that if you're still in the selection phase, it is a genuine intention. Now, I would say that if you're filing marks which you have no intention of ever using and they're just there as decoys, then that would be a situation where no, you don't have a genuine intention to use. Does that answer the question? Great. All right. So moving on to another consideration when filing, and that is that there's something somewhat unique to sports brands, which is that many of them are centrally managed at the league level rather than at the individual team level. And what this means is that the central management presents an opportunity for efficiency and cost savings because it means that leagues can develop standardized lists of acceptable goods and services, those which are unlikely to receive multiple objections from the trademarks office, and implement harmonized filing strategies across all league brands, so for multiple teams. Doing so ensures consistency and protection across the league with simplified portfolio management and a reduction in duplication of efforts. Next slide. Sports brands also present a unique opportunity to leverage non-traditional trademarks in a way that other industries might not be able to. And this is because sports brands revolve around the fan experience. It's not just the team's name and logo. It's the chants, it's the colors, it's the look and feel of the stadium experience. Our sports team should consider filing for position marks, such as the distinctive striping or design placement on our jerseys, for three-dimensional marks, such as our mascot or its unique costume designs, and for sound marks, such as our signature chants and stadium sounds. Obtaining registered trademark protection for these other brand elements can enhance our enforcement efforts, which Will is going to explore in greater detail later in the webinar. Next slide.
Before you go to the next one, Jimene, if I may.
Sure.
I really like the non-traditional marks aspect, but I think there are additional challenges when you try to secure registration for those non-traditional marks. You want to expand on that a bit?
I mean, yes. So if we can go back to the slide that dealt with non-traditional marks, I listed a couple here. Position marks, three-dimensional marks, sound marks. So some types of non-traditional marks, you can file and obtain registration on an inherent registrability basis. So without having to have proven that your mark has acquired distinctiveness or secondary meaning, such that it is recognized as a trademark. An example of that is a position mark. So a position marks, there's no automatic requirement to file evidence of acquired distinctiveness prior to the filing date. However, some types of non-traditional marks, such as sound marks, and some types of three-dimensional marks, not all, there is the requirement that in order to obtain a registration, you have to file evidence establishing that the trademark had been used to such a great extent prior to the Canadian filing date that it had developed acquired distinctiveness, secondary meaning as of that date. So, some of those marks, I think, they're not going to be involved in the first round of filings when the new team is launched, and you're going to necessarily have to wait until they develop a reputation so that you can claim that acquired distinctiveness. All right, so that takes us to our team's key filing takeaways. We should file early. We should file broadly but strategically. We should anticipate merchandising and licensing. We should leverage league level efficiencies. And we should think creatively about what elements of the brand can be protected. So, Francois, I hope that answered your question about what sports brands need to think about when seeking registered trademark protection.
Yes, but other questions pop up in my mind. So one of them, so I'm sure sports brands, they face challenges when it comes to maintaining the trademark portfolio for many years. Can you expand on that?
Absolutely. To answer your question, I'll start with a bit of legal background. So if we can go to the next slide. In Canada, a registration is vulnerable to cancellation if the trademark has not been used in Canada by the owner with the registered goods and services at any point within the last 3 years. This means that even if a trademark is recognizable and valuable, the registration may be subject to cancellation proceedings if the trademark has not been used in the recent past. In the sports context, non-use cancellation proceedings present a real risk for defunct or relocated team names, retired logos or mascots, and for tournament brands that only appear periodically. Next slide. So, but why should teams and leagues care about maintaining legacy brands? Well, oftentimes they're still deeply tied to the fan identity and history. As a consequence, they have value because fans still want a piece of that legacy brand, such as by owning retro merchandise. If a registration is lost due to non-use, the league or team may lose control over the brand, such as if a third party adopts or registers a similar mark. This loss of exclusivity could prove detrimental to licensing efforts. Next slide. So what can our sports team do about this risk? Well, the best practice is to put the marks into periodic use, such as by hosting throwback or nostalgia nights where players wear retro jerseys and where historical logos are displayed during the promotion and performance of the event. Our team can sell retro apparel and other merchandise bearing the legacy brands in the fan shop and online. These activities result in genuine use that is easy to document and directly tied to trademark rights. So, if our registration were ever challenged for non-use, we would have the proof needed to maintain it. Next slide. As for intermittent or tournament brands for events that occur only every few years, there may be a gap in direct evidence-related use that could put the registration at risk. Our sports league can bridge that gap by continuing to sell branded merchandise year-round and by using the brand while engaging fans through promotional campaigns between events, such as countdowns, retrospectives, and highlights. Next slide. So here are our team's key maintenance takeaways. We should identify which legacy and event-based marks are worth preserving. We should monitor and document sales and advertising to support proof of use. And, where possible, we should centralize maintenance at a league level to ensure consistent use across teams and align heritage initiatives with trademark maintenance. And that's all from me on maintaining legacy and intermittent brands.
Thank you, Jamilian. Very interesting. Now, turning to William, now that we've obtained protection for our trademarks, in practice, what do you see in terms of enforcement?
Thank you, Francois, and thank you, Jamilyn. Okay, so I'm going to tell you a little bit more about enforcement in professional sport, but before sharing a few examples with you of what we see in the marketplace, I think it's always important to think about the business of professional sport in general and the team's source of revenue. So obviously we have broadcasting and media rights that would include contracts with television networks or streaming services for broadcasting live games. We have ticket sales, of course, and revenues generated in connection with fans attending games. But we also have sponsorship and advertising. I'm sure everyone on this call at some point has seen in their in the downtown area or on television, ads such as ... the official beer of the ... or similar ads. And obviously we have merchandise and licensing that includes royalties generated from the sale of branded merchandise. So when we think about sponsorship and advertising, why would a company spend a lot of money for the privilege to use a team's brand? Like why would a sports restaurant or sport bar want to be the official sports bar of the, let's say, the Mark C's, to reuse Jamielin's example? In practice, the only reason why a business would pay thousands or millions of dollars to use a team's brand is because of the assurance that they'd be the only one using it in connection with their goods and services, or be part of a very small club of businesses that are allowed to use it. So, and what I mean by that is a brand is, in the context of advertising and sponsorship, is only valuable if others are not allowed to use it for free. So if a sports franchise allows others to use their logos, their colors, their indicia for free, well, the market would be instantly flooded and the brand would lose its value. So like I just mentioned, why would a sports bar pay for the right to use a brand if its competitors are allowed to use it for free? So exclusivity is really the source of the value of a team's brand in connection with sponsorships. So in connection with sponsorship and advertising, so the type of one of the most common type of infringement that we see is what I would call ambush marketing. And we have two types of ambush marketing. We have direct ambush and indirect ambush. And the example on the right would be an example of a direct ambush. So, but first, ambush marketing, it's an advertising tactic where a company attempts to associate itself with a sports brand without authorization and without paying the official sponsorship fees. And the goal really is to capitalize on the sports brand's massive audience and steal the spotlight from legitimate sponsors. So the image on the right, it's a very common type of ad that we would see on social media. And I'd say that it's even more common nowadays in the age of AI. So what we've noticed in recent year and partly in the last 12 months is that infringing ads, especially from let's say smaller infringers, are getting more and more sophisticated, or rather the quality of the infringing ads are getting better. So instead of just copy pasting a logo on an image that would end up on social media, now we see very high quality image or ads that are being generated by AI. And the increase of quality is a concern because when an ad is of very high quality, it gives the impression that when something looks good, it looks a bit more official, right? And when you look at official ads, like actual ads from actual sponsors, they look very good and they look professional. And like historically, it's been easier for consumers and in general to distinguish between an infringing ad and a real ad just by comparing quality. But nowadays, in the age of AI, that's becoming more difficult. Infringing ads are, look better, they look more official, and the ad on the screen would be an example of what we see a lot in the marketplace. So in this ad, we see. So for the following slides, I'll reuse Marksy. So we'll pretend that Marksy is a sports team. So here we have the logo, team's logo reproduced, but we, on the top of the image, underneath the words just dedicated, we see the words the official home of real fans. And phrases like that are quite common. And here, what is not written is it doesn't say official sponsor, it doesn't say official partner, but we have use such as the official home or something like that. We have use of terms that are intended to trick consumers or increase the risk that there'd be a mental association between the business and the sports team. And that is quite common. So, so direct ambush, again, it's really the intentional use of protected trademark and indicia to mislead consumers into believing that the infringer is a sponsor. And we have another example on the left, a very common example of, let's say, an ad on Instagram where a business is trying to associate itself without permission with a sports team. And on the left, we have another common example, and we I generated this image with Copilot, and I agree that it might be a bit much. There's a lot of Marxist decor in this image, but it's not, it's not an entirely unrealistic example either. Like, this is something that we do see restaurants and local businesses use a lot of decor, branded decor in their restaurants or business. And in the context of a restaurant, when we see decors like this, there's always a risk that, well, not only it is infringement because it is use of a mark in someone's advertising without permission, but it also, when we see the decorations like that, it also can lead consumers into thinking that this is an official bar because it somewhat looks like the decor that we would see in a restaurant that is inside or that is connected to a stadium. And when we have flags or decors like that being used, from our perspective, the goal is clear. It's to create an association, and it's to use the team's goodwill in someone's advertising, and that is infringement. Another very common type of infringing ad that we see is just like the one we see on the right, where there's the context would be contests or raffles or winning a prize. And so in this example right here, and again, it's very, very common. We have a company that is offering tickets. To win, you need to repost the publication. You need to comment on it. You need to follow. And the contest ends on June 3rd. And one of the person who's done those things will win 2 tickets to the next Marxist games. That is very, very common. So what do we do when we see something like this? Well, obviously, just like any other type of infringement, we collect evidence, we send cease and desist letters. But in the context of social media posts, especially when we have use of a team's logo, takedowns are a very powerful tool. They're powerful because they can lead to quick removal of infringing content. So takedown, it's essentially social media platforms, they have a formal process to remove infringing content. It's usually a simple form that you need to fill out, and provided that you can point out to registered copyright and trademark design, it usually works, and it's fairly quick. But it's powerful. Takedowns are powerful not just because it can lead to quick removal of content, but there's also a psychological impact of having content removed, because at that point, and that usually is powerful in having people complied with broader demands. Because once a content is taken down, you have essentially 3 people that are telling you that what you did is wrong, right? You have a team or a league, they're lawyers, but then you have a social media platform like Meta that is essentially telling you, yeah, we've looked at the complaint, we've looked at the takedown request, and we agree that you shouldn't have posted this. It violates our terms and conditions, so therefore we're going to remove it. And when an infringer, especially an not very sophisticated one, it receives a notice from Instagram followed by a letter from us, it usually helps in getting them to comply with other demands. It's very helpful also to point out to infringers that particularly in the event of repeated infringement, social media platforms can ban an account. And particularly in 2026, for a small business, if we ban their Instagram account or Facebook account, it can have some serious damage, and explaining that to them, that repeated infringement can lead to these consequences that are beyond, the traditional route, that we take for against infringers. That is also very powerful, and it helps with compliance. In the context of tickets, another important point is to mention that so all sports. So when you purchase tickets, the terms and conditions pretty much always provide that tickets distributed in the context of raffles, contests may be void, and winners may be refused entry into a stadium. And when we can point out to an infringer the specific paragraph in the terms and conditions where it says that if they proceed with a contest and then the tickets will be canceled, that is also very helpful in for compliance, because it would be very embarrassing for a business if they were to distribute tickets to winners, probably one of their customer, and then customer shows up to the stadium and then they're refused entry. And at that point, that can be very embarrassing for a business. So when we explain that to an infringer, it also helps with compliance.
Although, William, if I may, it would be very frustrating for the fan not to be able to attend the event because
Of
of
course,
something that they didn't do with themselves.
of course.
Yeah.
That's why also quick, communication with a business is important. When these things come up, you always have to deal with them right away. So you give a company plenty of time to come up with a new price and replace the tickets for cash instead of a ticket. Another type of interest that we see, I would call it indirect ambush. So that would be using indicia of a sports team, but not logos, not team names, but still with the clear goal of drawing a connection between the infringer and the team. So in the example that you see on the screen, we're going to pretend that the person in the image is a famous player of the Marxies. It's a very famous player that every fan of that team would recognize, and we'll also pretend that the jersey worn by this person is the Marxies jersey, but intentionally the logo of the Marxies was removed, right? So in this case, again, there's no team name, there's no logo, but people at home would clearly recognize that that this here refers to the Marxists. People would recognize the jersey, they'd recognize the person, and they'd know that this person here is a player of the Marxists. And then that's a problem because it becomes a problem when the consumers clearly recognize team indicia in the image. And the problem is not that there's a famous player. It would be entirely different if he was wearing day-to-day clothing and there were no other indicia. But when all these elements are used together, there is a mental association between the ad and the team, and at that point it becomes infringement. And these types of ads are very common. Another type of ad that we see a lot would be, again, no reference to a team name or a logo, but use of other indicia such as modified mascots and references to a team's location. So in the example that you see on the screen, perhaps you'll remember from earlier, the mascot of the Marxists was a badger. So in this image here, we see a badger. It's not the badger. It's not the team's mascot, but it's still a badger. And let's say that this ad that was posted in the context of ongoing championship between the Marxists, let's say that they're from Toronto, and then a team from Tampa Bay in Florida. So one type of ad that we see, indirect ambush ad that we see would be something like this, where there is a modified badger followed by references to the team. So here we have, let's go Toronto, send Tampa back to the beach. And these ads, very common, and sometimes they're used with video footage of live games, short footage, such that they're not necessarily copyright infringement, but there's a combination of elements such that when people at home watch or look at these ads, like clearly they would think of the team, they think of their indicia, and at that point, that's it becomes infringement. Another type of very common infringement is counterfeit. There's a lot of counterfeit in Canada. Some people might be surprised by that. For sports apparel, in practice, we see that they're often purchased from Alibaba. Alibaba is a major source of counterfeit products in Canada. They're usually pretty inexpensive. Like I've seen jerseys bought on Alibaba by infringers for as little as $3 to $5 a jersey. But I'd say for jerseys, usually it range between $20 to $30 per jersey, 35, something like that. And usually it's pretty easy to tell that whether a jersey is counterfeit. You can tell with pictures for many reasons. You have poor quality hologram tags, which are usually included on licensed jerseys. They imported from countries where we know the product wasn't made in. For example, for jerseys, we know that the leagues jerseys are manufactured in this country, and then in practice we can see that some of them are imported from China. That's usually a tell. But I think the easiest way to know whether counterfeit or not is just by looking at it. What we see is that counterfeit jerseys, bad quality product, bad quality fabric, bad stitching is very common. So these two images that you see here, they were generated by AI, and perhaps the example on the right, that one is really bad. But in practice, this is truly something that you see, just strings, everywhere coming out of the jersey. You can really tell. And good quality jerseys, tend to be perfect. You really do not see any imperfections in general. So another thing that you see a lot on counterfeit jerseys is logos will be glued as opposed to stitched. That's something that you see a lot as well. In connection with merchandise, another type of infringement that we see a lot would be people modifying team branding or mascots and creating different versions of those indicia. So here, on the example that you see on the screen, someone would have created an entirely new image, but at the end of the day, the Marxi's mascot is very, very recognizable, and at that point, it becomes infringement. So going back to counterfeits, one of the most powerful tool to deal with counterfeits in the context of sports is RFAs, so what we call request for assistance. So it's essentially a formal process to get the Canadian Border Service Agency to help us fight counterfeit at the border. So in a nutshell, how it works is we file an application with the CBSA. We provide a list of registered trademarks and copyrights to them, and when it's accepted, if a border officer encounters suspected counterfeit goods during their day-to-day inspection, they will open the shipment, they will open the box, they'll take pictures of the product, they'll send those pictures to us, and they'll ask us to confirm whether the goods are counterfeit or not. When we confirm, and then once we have those photos, we have 3 days to confirm. Once we confirm that the goods are counterfeit, at that point, the goods are detained by the CBSA. It's temporarily detention, but it's still very powerful because at that point, we'll also be notified of, we'll be provided information on the importer. So usually the CBSA will send us a picture of the shipping label, and at that point, we'll have the importer's name, their address, their phone number. So it's extremely helpful first in identifying importers. One thing we see, what is difficult, for instance, is figuring out who the infringer is when goods are sold on Facebook Marketplace, right? Because anybody can create a Facebook Marketplace account, fake name, fake everything. And at that point, it can be hard to identify someone. But through the RFA process, we can know with higher level of certainty who this person is. Like, we have their name. Yeah, they can fake their name, but it's harder to fake your address, your home address. You're not meeting someone, unlike Facebook Marketplace. Let's say you're sending an investigator, like, you're not necessarily meeting them in the parking lot, a mall's parking lot. No, you have their personal address, and then you can do some investigation to confirm that the importer's name matches with the person who owns a property. So it's very, very helpful in that respect. And it's very, and also in practice, so I should have mentioned, so once we have confirmed that goods are counterfeit with the CBSA, then we have 10 days. 10 days to either enter into an agreement with the importer, allowing us to destroy the seized goods, or initiate civil court proceeding against the infringer. And that can sound scary to some, to say that once we know someone's identity, we have 10 days to sue them. But I don't think that should be a deterrent to using the RFA tool. First, I think in practice, we have a very, very high success rate at getting infringers to agree to having the goods destroyed. Like, in practice, because there's some real psychological effect of getting a cease and desist letter in the context of RFA. Because so when we send a cease and desist letter, we'll include pictures, right, at the end, and it will show the goods that we seize. But it's not just pictures of jerseys. Like, in practice, when CBSA agents send us pictures, what they do is they take their phone, they take the goods out, they put them on a desk or something like that, and then they'll take pictures. But in the picture, what you see plastic black gloves, and sometimes you see the CBSA agent's belt, and then you have you can see all the boxes open and all the goods displayed on a table. And prior to receiving a letter from us, the infringer will also have been advised by the CBSA that their goods have been seized and are being detained. So when they receive our letter with the pictures, it's very scary for an infringer. At that point, people know and realize that, one, well, we know who they are. We have very good evidence that they've done something wrong. And also, the government is involved. The police or the CBSA officers, they're looking into someone. So that extra level of involvement from the government in this has a significant psychological impact on infringers, and that really helps with compliance. In practice, most the large majority of infringers will agree quickly to having their goods destroyed. And something else that's very, very helpful with RFAs is, even where an infringer does not cooperate at all, and even where we have no intention to sue, let's say. So we write to someone, we receive no response, someone is not engaging, and because of the scale of let's say we didn't seize much, and we have no information to think that someone imported more. Let's say that we have no intention of suing somebody. Using the RFA program here is so extremely helpful in delaying when the counterfeit goods enter the market. As I said earlier, when CBSA agents think goods are counterfeit, they'll put them aside and then inform us, and then we have 3 days to confirm that they're counterfeit. So hopefully the 3 days, line up with a weekend. It's 3 business days. So hopefully it lines up with a weekend. And then after that, we have 10 business days to do something about it, either sue someone or get the importer's consent for destruction. So essentially, we have 3 to 4 weeks. We can delay arrival of products in the market by 3 to 4 weeks. And in practice, infringers, they tend to import these types of goods during championships, right? And sometimes they order as they go. They don't necessarily want to have an gigantic inventory of counterfeit goods. Sometimes they want to have a little bit, and then they keep ordering when their inventory gets depleted. So in practice, by delaying the arrival of products by 3 to 4 weeks, it's entirely possible that by the time the goods are released, your favorite team has been eliminated, right, from the championship. And at that point, these counterfeit products have a lot less value, and your client has been able to continue selling legitimate items. So even if the goods are released, just delaying the arrival of products is still very, very powerful. So I'd say the RFA program is very strong tool that is in our toolbox to fighting counterfeit. Okay, so I'll pass the ball back to Francois.
Thank you, William. That brings us to the Q&A portion of the presentation. So remember, you can continue to submit questions via the Q&A panel at the bottom of your screen. We have one here. I think it's for both of you. The question is there also a right of publicity in Canada for the player's image? And I think I would like to get the point of view from someone from common law and from someone from civil law.
Yeah.
Okay, I'll go first just to give Will a chance to catch his breath and rest his voice. So yes, there is a right of publicity which is recognized in common law in Canada, and it's tied very much to the value that the person who is claiming the right of publicity, the value that they can be associated with their name, likeness, and image, and so. I probably don't, my value of publicity, my name, likeness, and image is probably not worth much. But if I was a famous football star, then there would be a great value attached to that. And so what that means is if you have, if someone tries to, like a business tries to associate their company with that person by putting their image or their likeness or their nickname or even their jersey number, and somehow drawing an association, then that is an actionable tort that can be that, and the public figure can seek damages, which would be equivalent to their loss of royalties, where they have to legitimately license the use of their name, likeness, and image.
I agree entirely. I might just add that rights in someone's image in the context of famous players are not necessarily enforced by the teams or leagues, but they may be enforced by the player himself or by a third party where that image was licensed for a specific purpose. But yeah, generally it rests with the player, him or herself.
Thank you. Next question. So for a smaller team with a lower budget, for example, minor league, would it be sufficient to rely on common law trademark rights rather than registration? Jimmy Lynn?
Yeah, I guess I'll handle that because I talked about the registration portion. I mean, yeah, it's at the end of the day, I say you let your sales drive your filing strategy, and that has to be balanced against the risk of someone else taking your brand. So in Canada and in some other jurisdictions, we are what is called a first to use country. So if you've started using your minor league team name, logo, but you haven't filed a registration for it, you still have rights. You have these reputation-based rights, which are assertable in any geographic area in Canada where you have that reputation. And so you can assert those in what's called a passing off action and prevent people from using a confusing mark. Now, it can be very, it's more challenging to assert common law rights because you have to prove that level of goodwill and recognition, and it's limited because it's only in the geographic area where you have those rights. And whereas a registration extends across Canada in most instances, and it is your presumption that you have the right, and all you need to prove at that point to assert it is confusion, or likelihood of confusion. And so, no, you don't need to, because we are a first to use country. Now, there are other jurisdictions which are first to file, and so there's a greater risk in not securing a registration early. But I'll let Will jump in if he has a contrary view.
I do not.
Perfect. We're approaching the end of our scheduled time, but I've got one question for you, William. So sports brands have emotional values, obviously, because fans are crazy about their teams. How do you deal when the infringement is by I don't want to say over enthusiastic fan, but something similar, a fan that uses the trademarks of his favorite team and maybe goes a bit too far?
We definitely see that a lot. I don't think people are necessarily in bad faith. So I think education is the key when dealing with unsophisticated infringers. Enthusiasm is definitely a source of an infringement in professional sport, especially when you see other businesses doing the same thing. You may very well think, oh, I should do this. I should do this as well. But at the end of the day, it's still theft, right? They could obtain a license, but to do that, they'd have to pay something, and they're choosing not to. And during championships, we see a lot of infringement, and people do that because it works. When you use a famous team brand in your advertising, it really does capture consumers' attention. It truly helps your reach on social media. So when people do that, they get a lot more views on, let's say, on Instagram or Facebook, as opposed to just a normal, like I was talking about contests earlier. This is like, it's extremely successful. People in having people interact with your social media account. So you're trying to reach as many people as possible. A raffle for tickets for the Marxies, is a very, very good way to get a lot of eyeballs on your Instagram account. So people do it because it benefits them financially. And at the end of the day, even when someone is sophisticated, the outcome is still the same. They should have paid for something they didn't, and they're undermining a licensing scheme, and it's still infringement. But when dealing with those type of infringers, it's important to be patient, to have an approach that's focused on education, not necessarily confrontation. And I think in practice, when we explain to people why they can't do something, then they generally understand, comply, and they don't repeat. That's the majority of people. And at that point, we've achieved our goals, and we've not undermined anybody's reputation. And people tend to not repeat.
And I think, well, that's a great answer. And I think it also, if you're too heavy-handed with those types of infringers, then it could really backfire on the brand, which is what this whole exercise is about. It's about protecting and maintaining the value of the brand.
Thank you both. With that, we've reached the end of the Q&A session and the presentation. So thank you so much for your participation and your insightful questions. As a reminder, when the webinar ends, a survey link will pop up on your screen. Please do take a few moments to share your feedback. And if we look ahead, we have another webinar on June 16 from 12 to 1 Eastern, titled Proactive and Reactive Strategies to Protect Your Brand at the Border and on the Web. So I'm pretty sure we'll talk about RFAs again. Again, it's on June 16 with Graham Hood and Tamara Weingus from our Toronto office. So thank you again for joining us today. Thanks, Jamie Lynn and William, and we hope to see you at our future sessions. Thank you.